Good morning. Today in this video, let us consider the right to silence. Silence is no longer golden. What is the right to silence? Before I answer that question, I have to tell you that the right to silence has two components. The first one is pre-trial right to silence. The second one is at-trial right to silence. What is pre-trial right to silence? First of all, we must understand the law enforcement authorities, example police, have the right power to investigate a crime, or if they suspect there's a crime is going to be committed, they have the power to investigate. But we also must point out that citizens have a moral or social duty to help the police, but no legal duty to help the police. Except the police or law enforcement authority ask, they have to give the name, address, the telephone number. More than that, they don't need to give any information to the police during the investigation. When you investigate a crime, the law enforcement authorities have to caution a suspect. They have to say, you don't need to say anything about this, but if you say anything, we'll take it down and it will be admitted as evidence in the court of law, in the case against you. Now let us consider what is at-trial silence. During the earlier stages of criminal law and evidence, accused was neither a competent witness nor a compellable witness. But now, the present position is the accused is competent witness in his case, but not compellable witness. That is, he has the right not to testify. Other point I would like to make is, you consider most of the jurisdictions around the world, accused persons have three ways to advance their defenses. Number one, they can remain silent and ask the prosecution to prove beyond reasonable doubt. Number two, they can give evidence on oath and subject to cross-examination by the prosecution counsel. Number three, although this is not very popular at the moment, they can make a doc statement or unsworn statement and they are not subject to cross-examination. These are three ways an accused person can advance his defense. Now let us consider some of the deeper investigation of these issues by various government bodies. In 1975, the Australian Law Reform Commission report on criminal investigation handed out its report. This is regarding the pre-trial right to silence. Law Reform Commission recommended the retention of the pre-trial silence for the following reasons. I will let you know what are the reasons for the Law Reform Commission to retain the right to silence, pre-trial right to silence, in part 2 of this video. Thank you very much for listening. Have a nice day.